So the only problem I have now is that I got a headache from headbanging.
Nice.
Well, that was quite a shall I say, nonpartisan opening. That didn't take a side at all.
Yeah, I want to smite people. I want to smite people now.
Bill.
Yeah. Ooh.
Up there.
Pants with the 10 gifted memberships. Ooh.
I got a membership.
Thank you, Pants. Can somebody read them up?
Let's see.
Marion Schuster.
I don't see
them. Oh
them.
my gosh. Max 23, William George Fraser. I got one. Gia got one. Cicero got one.
Ooh.
Prosecco Rose.
Moist.
Craigie Elder God and Steve Z.
Nice. Wow. Welcome. All right.
7 days already added on, and it's only the first, 4 minutes of the show?
Unsupervised, and it shows. Yes, it does.
Most of that was the intro. So, does it
hey,
really
Becca, hon.
Hey, hon.
Becca.
Okay, we are up to 83 days.
Yep.
84. Sorry, I didn't get too shady. Yeah, 84 days.
And remind me what the 84 days is?
We have it on the scroll. For every $5, you get to add 1 day to Jim's torture, which is how many days he cannot have Taco Bell or KFC, which for him is a very big deal.
Yep.
Someone seems to be piping into the chat. I don't know.
What?
Must be hacked.
Yeah, that's not the real Jim.
Oh yeah, no, it's not the real Jim.
He should be in bed resting.
Yeah.
He is in bed resting because we know he's not really the overlord management that we all keep claiming he is by his constantly butting into what we're doing.
Yep.
Union.
Yes, that's what I've been saying. That's what we've been saying.
Oh my goodness. Hello, everybody.
Yeah.
Okay, well.
Bring all the coin and he bitches.
I know. Oh, by the way, we do have a Facebook entry, so I would say, hi, David!
Hi, David!
Hey, Dave!
Hey, David!
David!
You have to yell really loud so that Facebook can hear you.
Yeah, Pants, he really should get his own channel.
I know. He should, shouldn't he?
Yep. Freeloader.
We do have an exciting thing to cover today. Exciting. I mean, I kind of hesitate to bring it up because, well, let's see if we can bring this on screen here. All right. Can everybody see this?
Yes.
This is from Laura Conover, the Pima County attorney. Now, you might find this interesting, Judy.
Oh, I have read it. Yes.
And you remember when you were in court and Wayne made the claim he didn't have access to the law library.
And he said there were like 2 tablets.
No, we're getting there. Let's go with the first thing though. That he had gone to
Karen.
Hey, Karen!
Hi, Karen!
I'll do it first, and then Mark does it.
He had gone to the jailers and asked them about access to the law library, and they told him they haven't had one for 2 years. For 2 years, right? And so he was complaining that he did not have access. And that there, and then
he's pro se, so he needs it.
Right. And so go with the tablet, because he brought up they did have access. The prosecutor said, I think they have access to a tablet. So go with the tablet.
And the prosecutor did. I mean, she was kind of leaning over and talking with the sheriff, the sheriff's deputy, because of course Pima County sheriffs run the adult detention center. So she was kind of leaning over and so is this true? Is what's going on? What really is going on? And so she had said during the hearing that she would call the warden and make sure that he would have access via the tablet. There was access to a virtual law library via the
Mhm.
tablet.
Mhm.
To which Lane said, "Yeah, but they're like 2 tablets for 25 prisoners, and it only gets charged once a day. So, like, if you get 5 minutes, you're lucky."
And he was trying to be magnanimous because he didn't want to take up all the other prisoners' time.
That is true.
Yeah, he's a
That is
giver.
true. He
Yep.
is a giver, Gia.
Yep. Yep.
He
Okay,
is.
so now that we have that stage set, let's read this letter from the Pima County Sheriff. Now, this is Pantson's favorite phrasing right here. Comes now. Yes, Pants, come now. The state of Arizona, by and through the Pima County Attorney Laura Conover and her deputy Rachel Stiles, and hereby files this notice regarding the defendant's access to legal resources. The defendant's motion to represent himself was granted on March 20th, 2025, in this case number. William Parvin, Esquire, was appointed as the defendant's advisory counsel at the same time. On March 28, 2025, the court ordered that the defendant be permitted to access the law library at the Pima County Jail in this cause number. On April 1st, 2025, the defendant informed the court and counsel that the jail does not have a law library anymore and that he had not been able to access legal resources to be able to represent himself. And there is a footnote. The defendant further stated that there was one tablet for 25 inmates. The state contacted the Pima County Jail regarding the defendants being able to access legal materials. On April 2nd, 2025, the state learned that each tablet is stocked with legal research resources via LexisNexis. The jail
And
has a couch. Yeah.
LexisNexis is that's good stuff.
Yes, it is.
Yeah,
So it's not like it is. Yeah. So it's not like it's a 20-year out of date moldy law book that half the pages are torn out of. This is
Yes,
LexisNexis.
this
Come
is
on,
up
people.
to date. Yes. The jail has a contract with LexisNexis and it is free for inmates to access. The state has also learned that there is one tablet issued for every 2-person cell. The jail confirmed the law library is available to every inmate now electronically through the tablet. On April 10th, 2025, the captain of the jail confirmed that the defendant has been constantly accessing the law library via LexisNexis on his tablet since March 21st, 2025. Now, again, remember, this is before his representation in court that he didn't have access to this.
And I will also note that Ms. Stiles, the Pima County prosecutor, made the call the next day after the hearing.
Yep.
So she wasn't, oh, I'll take care of this later. The next day, which I believe was a Saturday, she called. So,
Right.
yeah.
Her day off.
Yes. The defendant is able to have the materials he needs printed by putting in a request with the law librarian. He's able to access writing materials by purchasing through the commissary, or if he is indigent, by putting in a request form, and they will be provided. So that was his claim. He didn't even have writing material. Furthermore, the state reached out to the Office of Court Appointed Counsel Counsel was informed that Mr. Parvin, the defendant's advisory attorney, can request writing material if his client is indigent, and those can be provided. Additionally, Mr. Parvin can be provided with a laptop with the applications necessary to review the electronic disclosure with the defendant.
Now, I doubt that'll happen because Mr. Parvin has said several times he likes to just go in with his phone, which has, it's one of those big oversized screens,
Right.
and then just pull up everything on his phone.
Right.
But I mean, sounds like he has access. He may have to file a request, but he has access.
Correct. That is
Oh.
basically what they're saying is, had he been under oath, he would have committed perjury.
Yep.
Bill,
Never.
Yeah.
thank you, Dave.
Oh, sorry. Thank you, Dave, for the $5 super chat. So how many more times is Lane going to get the FO part of FAO? Yeah. Uh-huh. Yes.
At least a dozen more times.
Yes. At least a dozen more times. She will continue. Lane, again, Lane is a living example of Dunning-Kruger at work. Despite all evidence to the contrary that he's wrong, he cannot accept it. He's right. He's right, and just ask him. He'll tell you he's right. Can somebody else pick up the reading for a minute?
I'll happily do it. In State v. O. Henry, at this address, we'll say, the Arizona Supreme Court noted that a criminal defendant has constitutional right to represent himself. The court found that when, quote, a defendant in custody exercises that right, the Fifth Amendment guarantee of access to the courts requires that he or she be provided an adequate law library or assistance from someone trained in the law. The court also notes that library access is only one permissible means of affording the right of meaningful self-representation. Legal help is another. Furthermore, the court held that an inmate does not have the right to select his or her preferred means of access. You get access. You don't get to say how it happens. That's what that means. Due process rights are violated only.
I
when it
want
is-
a lawyer.
Yeah, that's right. Due process rights are violated only when it is. Due process rights are violated only when a defendant is denied all meaningful access to prepare a defense. In this case, the defendant has access to an electronic law library to do legal research. In this case, he also has an advisory attorney who is able to assist him in his defense and is able to provide him access to be able to review all the discovery in this case. Respectfully submitted this 10th day of April, 2025.
So, there we go. Lane,
In other
you're
words,
full of shit.
F you.
Mhm. Hence,
So-
I would say yes, it is still frowned upon to lie to the judge, to mischaracterize because he said that he had no pencil and paper. He was taking notes with what I don't know, but apparently taking notes on the back of motions.
Then how could his attorney not know this fact?
In open court.
Well,
How could
that's
his
right.
attorney
Tuesday,
not
said
know
that in
that
But
he's
his
got a
attor-
tablet?
Okay, but his attorney isn't making the representation. Lane is,
Oh,
right?
yeah.
And so
And-
if he does not have direct knowledge of anything contradictory, which he may not, right? He may not know the inner workings of the jail and what the jail is doing.
So Lane lied to him
Oh.
too.
Well, let me tell you, I mean,
possibly.
Harvin does not know how the jail works because, again,
Right.
he wanted to just hand the glasses to Lane.
Yeah.
Right.
And the bailiff was like, no.
Yep.
What we're not going to do is hand things directly to him.
And the other thing is, the prosecutor didn't know because they had to contact the jail to find out the information.
Yeah.
So-
and I think I think the prosecutor wanted to make sure she had all of her facts in line,
Yes. Yes.
so that she could write this motion and say, "Nice try, but
Right.
no."
Yeah.
Right. Right. So
Wow.
I think the prosecutor is doing what they need to do. They're covering their ass and covering their bases and going, nice try, Lee. Because if he tries to take that to what they're trying to do is perfect an appeal,
Yeah.
right? Because Lane's going to appeal everything, and if this is one of his bases for appeals, then they can argue, no, he's incorrect in that.
And he would have got away with it too if it wasn't for that meddling judge.
Those meddling kids.
Sue Bear, she does kind of remind me of Debbie Davis too. Rachel
Yeah,
Stiles is a no-nonsense woman who knows her stuff.
right.
So yeah.
The other thing, there's another piece of news we need to cover. Apparently, little Chilly Willy has missed a few deadlines.
Oh
Wait,
yeah.
wait.
Pikachu
Well,
face. Pikachu face.
it
I,
makes
that's never happened before.
Shocked,
it
shocked,
honestly
shocked, and
does.
shocked.
It does make a change to him missing the toilet seat. So it's that.
Yeah, pants. Contempt is a possibility. They could also add a charge of lying to a judicial official during an official proceeding.
Yep,
On the record.
Uh
yep. He's
On the
brilliant.
record, for the record, let the record show.
Yep.
huh.
But can he make a record?
He could make a record. He could just
Now,
go down to
here's
the
an
county. He
interesting
could go down to
question.
he could go down to the county fair, and do one of those booths, and for $5 make a record.
Pima County Fair is coming up. Of course, he'll be in custody, but that's fine. Here's a question for Mark or whoever else. If you are a citizen going pro se, but held to the same, canons as an attorney,
Uh-huh.
does that mean that for the purposes of hearings and trials and stuff, you have to make truthful representations to the judge as an officer of the court, or because you haven't been sworn in officially to the bar, that doesn't quite count?
No, it does count. Yes, you could be held in the same standards as a lawyer, but if a lawyer lying to a judge like that, again, is not perjury, it is contempt. And you could risk your law license for doing it.
Well, I know if he'd been sworn to the bar and all that kind of good stuff. Well, I'm wondering about if someone is proceeding pro se.
No. Okay,
If
so if you're under oath, right? If the judge
no,
swears you in, I know, but if the
Lane
judge swears you
wasn't
in,
sworn. Lane
right,
wasn't sworn when he made those statements.
right, and neither are attorneys, right? So an attorney
Right.
makes a factual, completely makes something up. They can be held in contempt, right? And they can get sanctioned by the judge. They would also be referred to the bar for disciplinary action and potentially lose their law license.
Question.
I completely understand. I'm talking
Right.
about someone acting as pro se.
Yes,
Yeah.
they could be held in contempt and they could face sanctions from the judge for the contempt.
Question.
Uh-huh.
Could he be told no pro se later for lying now?
That is a good
Different
question,
case.
Touche.
A different case. They say no, you lied before. Now no pro se.
Well,
It's
I'm wondering if it's even possible that because if Lane is found out to be a liar, pants on fire, no offense, pants, that if the judge can't take him at his word, that may that could be possibly a way for the judge to say you can't go pro se.
Yep.
I wonder.
Yeah, he's already been warned about it for
they
his
could
behavior.
the judge, it's possible for a judge to force counsel upon you if you've
Right.
proven that you can't abide by the court rules. And yes, I
I'm
would
just
think that
wondering if
lying to the judge would be constituted of this. Now, is that a big? It's not a particularly big lie, and he was found out. In my opinion, it's not a particularly big lie. And he was found out rather early on. If he persists with the lie, I think that will be a bigger issue for him. The bigger issue he has is he keeps violating the judge's order by producing videos and then flaunting them by going, "You can't make me do this."
is he doing that again?
Yes.
Well, yes,
Yes, they
several
can.
other channels. This seems to be happening. And by the way, pants does not take offense, and it would be painful for him because he's not wearing pants. So if it did light himself on fire, that would be really, really painful.
So I predict when he goes to court again, the prosecutor is going to have lots of ammunition for him continuing the behavior.
Yep.
Yep.
Oh, I just got some breaking news.
Oh, spill.
Someone who was supposed to be resting, but Jim just gave me an unofficial copy of let's see, State of Arizona versus Lane Myers from William Parvin, Esquire.
Ooh.
Defendant Lane Jeffrey Myers has motioned the court for rehearing on bond. Signed by Judge Metcalf, setting the matter for hearing on April 15th at 2 p.m.
Oh,
to
this is
determine
good.
whether the defendant is entitled to a rehearing on bond.
God. Yeah, it's going to be glorious.
Oh,
Waste of time.
oh, that's going to be good.
And you
gonna
have
be
it on
good.
your DMs, and we're both about to get 2 new documents because
Oh.
apparently Jim is not able to rest.
Yes, Jim has the ability to remain silent, just not the ability.
He has the right, not the
He has the
ability.
right, not the ability. Yes.
Typing is silent.
Well, I think I know where I'm going to be on the 15th at 2 p.m.
That should be a wonderful.
Sue Bear, what was your question?
Yeah, I'm sorry, Subarry. Ask your question again.
Has he been through the FREDA hearing?
No, he's not been through the FREDA hearing yet.
Which is that one?
Where they go over your right and ability to represent yourself.
He has for one case, but not this latest one, I believe.
Not the latest one. They haven't got to that yet.
Because that's why we were waiting before for the to be arraigned, so that then they could do the hearing for the latest charges. And I don't think he's, at least Jim, have you seen that he's been arraigned on the latest charges? Even though I don't know why I'm asking you to look that up for me.
Well, if he's going to participate, then he might as well participate.
I mean, may as well.
Jim message. Chat.
Oh.
He was arraigned off camera.
No, up higher.
Yeah, it keeps moving on me there. Okay.
Oh, the newscast.
Bill does text.
It was in the newscast.
Oh, gotcha.
Which we all apparently watched and took careful notes from. Sorry, Jim.
Yes.
Yeah,
I just got.
Oh, so yeah, they never went live. Remember when we all sat there and waited?
Oh,
for
yep.
nothing?
Oh,
Yep.
Yeah.
Yep.
Yep.
Okay, so in Cholito news, he's blown through 2 deadlines.
Surprise,
And
surprise.
shot.
Friday ended without a response in either motion in the Ironton and Nevada case.
Now, if
So,
I'm not mistaken, wasn't he told that he had to go and file back in Ohio?
How long has that thing been dragging on?
hello,
I
Pants.
lost count after a couple of years.
Good evening.
Good evening.
Do you have insight into this?
Not at all.
Oh,
I just
okay.
figured if you're having a party, and there
He's
might be
had
something
Oh,
else to
you
read.
the pants.
you wanted to join. Got it.
So wait a minute.
Got it.
Pants. You heard there was a party and you wanted your pants to be in the party.
Exactly.
But basically, he broke in. Like he and Lemon did the other day.
If as Jim will probably correct me because I probably am not remembering this quite right, but it seems to me that there was something he needed to perfect in Ohio, and he failed to do that. And I think it was service because
Paper and heat.
he had somebody go to the police department, throw papers at an officer, and go, there, they're served. One of which was Pam Wagner, who has retired. So even if you threw it at an officer, that wouldn't count as service to Pam Wagner because she's not there.
Yeah, that's not how it works.
Oh, fine.
I say we move on to the drunk girls.
Oh, and
well, hold on.
Unless we want to read Lane's motions.
I have a special thing just for this here. That wasn't it. That's not it.
We're all waiting on Phil's special thing.
I'm reading through a couple more documents, skimming through a couple more documents right now from Mr. Myers.
That wasn't wrong one. I had the wrong one.
These definitely sound like his lawyer's voice.
That doesn't surprise me,
Both
Phil. You sent
deadlines
us the wrong
imposed by
bloody link
Judge
to join.
Daniel J. Albrecht to
Here we go.
respond to the motions to dismiss his refiled case against members of the police force in Ironton, Ohio, and the County of Lawrence, Ohio. DeCastro had 2 weeks from the issuance of Judge Albright's individual orders to respond to the motions.
Aww.
That would have put the first deadline on
Oh,
Wednesday,
Muffin.
April 8th, 2025, with the second deadline on Thursday, April 9th,
I'm
2025.
reading his
As of midday on the West Coast on Friday, April
oh my
11th,
gosh, this is so
2025,
funny.
no filings have been made by DeCastro to answer either
Um,
motion as to why the lawsuit
I'm
shouldn't be out and
reading-
out dismissed or moved back to Ohio, as none of the participants
You're having
actually
fun,
live
aren't
in
you, Phil?
Nevada.
Yes.
DeCastro
I-
seemed
I'm reading
unfazed during a
Myers's,
Thursday live stream on
one
his
of
own
his
YouTube
motions
channel.
that
He
has
did not mention the ongoing
absolutely been
litigation, but
debunked
instead focused on the
by
evils
the
of the United
state's
States
motion
Supreme Court's Terry v.
that
Ohio
we just
decision.
read.
Strangely,
That is
DeCastro also
funny.
provided no updates during the stream to any of the projects he is working on, including his Constitution Headquarters board game.
Oh, now I
With
can't wait
19
to be
days
there.
until his end of this month
I
deadline
can't
to
wait to
release the
go on the
game,
15th.
DeCastro showed no urgency in finishing his product. Standing in front of the 30-4.
Now, aren't you glad we sent you down this rabbit hole?
You have freaking upended my life. Thank you. Thank you so much.
What are friends for?
You're welcome.
40-foot-tall wall of DeCastro's version of history,
Oh my
which
gosh,
he
I
built
think
in the
they
former
filed these
furniture
things
store
on the
he's
same
currently renting
day,
as studio space.
which is
DeCastro
hysterical.
ignored
Like
calls for
everybody got
updates from his
their
sidetrack to
motions
go
in
into
the
his
same
familiar Terry
day,
versus Ohio rant.
and that is hysterical because, like, one is directly like saying, I can't do this because law library is so bad. I can't do it. Boo hoo, boo
Right.
hoo. So therefore, it's all moot.
Right.
No, Muffin, it's not moot.
Hey, Gothic.
Hey, Gothic.
Glad you could join us.
Oh, I didn't realize what his full channel name was.
What Lane's was?
Uh-huh.
Oh,
Lane Meyer's Channel for Nonviolent Social Change.
uh-huh,
uh-huh.
But yet you call for violence all the goddamn time.
uh-huh.
No. It specifically says nonviolent. Surely you must be wrong, NCR.
I was only wrong about one time, and that was when I dated a Karen.
I was wrong about one time, but it turns out I was wrong about that.
Yeah.
See?
DeCastro did not update his other projects, including his Get People Out of Jail website, his henchmen from the 1960s Batman
there's some
TV
good
show as
stuff in here.
goodies, nor his legal document that he's planning to distribute to allow anyone to sleep in their cars without police interference.
I think we might
The
have
only place that DeCastro
differing
has,
definitions
in fact,
for a
been active on
statement
Twitter
of facts.
/X,
We
where
may
he has
just.
been posting
I'm
misogynist
going to
rants
agree to
about women
disagree
in
with him
power.
on some of these
In a
subjects.
recent post, DeCastro said, "Gross. There's nothing more authoritarian than a woman in power. It's disgusting. We see it in the police.
Yeah, I think Pants needs to do some
Women
reading.
cops are physically
This is what I'm
aggressive
thinking.
and hostile
Okay.
and then
Boy, oh,
rely
boy, oh.
on men to come in
Boy,
and
oh,
beat up the
boy.
person who they picked a fight with. This is disgusting. As a Gen Zer, we all said that we were going to end this bullshit war on drugs when our generation got to power. Look.
What was this one?
Okay.
Wait a minute.
More of the same
Why
bullshit.
are we listening to
Julia
an
said
AI
he's a
voice?
Gen
Castro's
Z?
lack of urgency was a hallmark of his hand.
Well, because Jim has supervisory power.
Yeah. But we could pull up his newspaper and, read it and show the people the text at the same time. I'm just being difficult.
I know.
It's my job.
Are you asking Phil to tech?
Yeah.
Yes.
Okay. Well, that's just wrong. Oh, here we go, Pam.
Mark.
There you go. Have at it. Have at it.
Defendant, Lane Myers, by and through counsel, William J. Parvin, respectfully moves to dismiss all aggravated harassment charges, which in this case include counts 1 and 2, because the statute currently in effect is vague, overbroad, and violates the First Amendment. Although the Arizona Court of Appeals previously ruled the harassment statute was constitutional, that ruling involved an older version of the statute no longer in effect. In 2022, the legislature modified harassment.
Stop removing me, Phil.
Go to bed.
God bless it.
I'm running this show.
I know.
Well, I mean, he's running something.
Am I supposed to hide the illegal craps game now?
Do I have to put on my pants?
Nope.
No.
Pants,
Oh.
these are over in group chat if you want to read them directly.
We have it in front of us.
And also, any PayPal would be appreciated because these are stacking up. They're $10 a shot for these PDFs.
Holy cow.
God.
Yeah.
Yeah, Arizona's expensive.
Crazy.
Yeah, it's
And-
a pain in the ass. So.
And to further incentivize those for PayPal, we need to beat Lane Meyer.
Yeah, we yeah, we do, but yeah, there's also articles on that today. He got $100 yesterday because we mentioned him on the frickin' air.
Yeah.
It happened exactly as we mentioned that he hadn't had a donation in 6 days. So someone's out there lurking and donated $100. So I am going back to lurking. I just think it's pretty with this layout. Look at this layout. We've got people on both sides now. We've got 3 on the.
We are very
wonderful.
special.
Yeah.
I figured it out.
We're bringing it, Jim. We're bringing it.
Yes.
This is high quality entertainment.
And don't forget that PayPals do count as adding days to Jim's
Yes.
punishment.
Yes, they do.
True.
I
Yes,
will.
they do.
Yes, they do.
Why am I next to Mark? Not fair.
Uh,
I am
Well,
just
if
I'm
that,
sorry,
that's
Touche.
true, then
Thank
Jim
you.
might never eat Taco Bell
His
again.
eye is in
Wait
the
a minute.
middle.
Wait a minute. Mrs. Tom has a theory. Jason Gutterman did it.
Hey,
Wait,
unclean.
Jason Gutterman did what?
hey,
Hey,
unclean.
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 Well,
Hey,
good
unclean.
night, all. You've got the
The-
breaking news. I will write up these reports tomorrow morning and have them out as part of tomorrow's newspaper. But yeah, Myers is an idiot. Parvin's an idiot. They're
Nothing
all
new.
idiots.
Yep.
And we will be providing live coverage as long as it's live on Tuesday of this next hearing. Hopefully Judy will be there so we can do an in-depth discussion Tuesday night.
Oh, she's going to be there. She's going to be there.
Plus, Karen Reed starts too.
Yeah, Karen Reed will be starting about around the same day. So, oh good.
Now,
Lord.
do we know?
You.
Thank you, Pants, for the 10 gifted memberships.
Sweet.
Why,
Oh, my
you're
God.
welcome. The
Oh,
memberships
green.
went to Pistina the First, CE, Sumi, VJH Berg, Griffkai, Mirrors 420, DAC, Luke, Strangier, Miss Bird Hunter, and my screen just froze. I can't.
Easy watchdog.
I can't. What?
Wait, Beasley
Oh,
watched
God.
that one?
Oh, God.
Oh, hell.
Wow.
Are you fucking serious?
Wow.
Oh, that's great.
Oh, hell.
Hey, BZ, welcome.
Screenshot it.
Basil, if you're out there, you owe me. You get a month of fun here. So, yeah, Basil.
Hey, Jim.
Yes.
Originally, I had in my notes that Tuesday the 15th was going to be a set trial hearing. Now we have all this, looking at bond again. Do you think it's all going to be at the same time?
It's all going to be at the same time.
2 o'clock, yay, not a 9 a.m. Woot,
So
woot.
pack snacks. Don't forget to pack snacks.
Stay hydrated.
And stay hydrated. Take water.
Yeah.
Oh,
water.
it's going to mean so much
and
water.
let's not forget, stay classy, San Diego.
And your camera
That's right.
pen. Your camera pen.
Stay classy. Okay, kids, I'm gonna go take drugs and go to sleep.
Yeah, right.
We've heard this. We've heard this before.
Eavesdropper.
Yep, I'm gonna take drugs and go to sleep. And
good.
Yep.
Love you, Jim. Love you, Jim.
Love you too.
Love you, Jim.
Love you too. Whoa! How'd Phil disappear? Whoa! See, gone back.
You bad boy.
So, as we were discussing, in 2022, the legislature modified harassment under 132921 by removing the requirement of intent. There is no decision by the Arizona Court of Appeals upholding the current statute. In fact, the legislature appears to acknowledge the mistake they made. House Bill 2043 is in the process of becoming law and will once again require intent. Additionally, this bill will make it clear that there is a defense to prosecution if the act is directed towards a public officer or employee and constitutes criticism. The current legislature is correct in believing they made a mistake. To protect the right of free speech for all of Arizona, this court must rule the current statute unconstitutional, as discussed in the following memorandum of points and authorities. See, this is the only good thing about all of these idiots getting arrested, is occasionally legally interesting points of law get discussed.
Yes.
Yep.
Yes. Yeah, they just changed a law in, where was it? I posted it, that they can't harass people at the courthouse or, yeah, they just new case law yesterday.
What state was that?
I'll find it. I'll find it.
Okay.
I posted it in Artie's channel. Are you in Artie's channel?
I am, but nobody reads what you post.
Yeah, it's in the sovereign citizen section of his channel.
I like how she just ignored that.
Now, Ohio is starting to pass their own version of the Halo law.
Yeah, wasn't it 14 feet?
Hey,
Is that
We're going.
Ohio?
Halo
We're going
being
like. The Halo law would protect harassment against first responders.
ooh, I like that.
Yeah.
In the performance of their duties.
Yes.
Yep.
So that means a police officer at a car talking to a driver and a douchebag on the corner going, "Give me your name and badge number. Give me your name and badge number."
Yep.
You can revoke consent.
Yeah.
Does that include firefighters and
Yes. Yes. And
Fires,
EMT?
ambulance workers
firefighters,
and
Yep.
yeah.
Yep.
Yeah.
Yeah. Firefighter just got
EMTs.
the shit beat out of him in Los Angeles.
That
Are
Well,
you
Guy
is
climbed in
serious?
the fire truck.
yeah. It was brought up during DMA's court hearing, right, where the judge pointed out that under Supreme Court precedents, right, the government has a right to control their property,
Yeah.
like anybody, like any other business, right, to
Right.
determine what's the purpose of the business. So them going in, I have business because
I want to
I
buy
say
one
I
stamp.
do. Yeah, because I say I do. Isn't that so? The government is actually stepping in and going, you know what? We need to start being more precise in our
Yeah.
language, and I think it's
Yep.
a good. And I think that this is the unintended consequence, and which is what we've been saying all along. There are going to be things now. You're going to restrict everybody's rights
Yep.
Yep.
Mm-hmm.
Yep.
because you want to be a douchebag. Like
Right.
it just.
For
Right.
you, Phil,
We've
I
been
would
saying this for a
definitely
while.
say I do.
Right.
Here's something. Here's something about the whole thing with the Social Security Administration buildings. Tyrant Terminator actually got owned a couple months ago because of that. Because they have made it now where the signs start, you can't film beyond the signs. So they're putting the signs right on the front doors before you even go in. So you can
Touche.
only film the
Your math is
outside.
spot on. By the way, sorry. Go ahead.
So if the signs are now at the front doors, you can't film beyond the front door.
Right.
So all you can film is outside, which is brilliant.
Well, and honestly, the stuff that's discussed inside a Social Security Administration office is very personal.
Yes.
So I'm good with that. I mean, I used to work for the Social Security Administration. Thank you very much. Yeah, like the most personal stuff a person can have.
DOB
So
address.
Yeah.
Well, and that idiot who was live streaming the jail calls, Josh Gray, the public service guy, he was convicted of filming in a Social Security office. So I read that,
that's
and he
not Josh
appealed and
Gray.
lost.
That's not Josh Gray. Josh Gray is Honor Your Oath, Civil Rights Investigations. Boshin is this is a public service.
No, you're other way around. Josh Gray is this is a public service.
Yeah.
Then there's two Josh Grays then.
Well, there's Jeff Gray. There's Jeff Gray.
Oh, that's right. That's right. I'm thinking Jeff.
Yeah.
My bad.
Yep.
I stand corrected. Apologies, everybody.
2 points from Hufflepuff.
I was never a Hufflepuff. I was Ravenclaw.
Anyway, as I was saying, I read I quickly read through the appeal, which was a beautifully written decision. Appeals courts often they love refining law, and it described in just excruciatingly simple language why their arguments about it being a free speech issue is complete bullshit.
Yep.
It's not a public forum. It's private information.
Right.
They had no business there. And so he was convicted.
Right.
Doesn't seem to have changed his mind.
And it has given case law. I mean, he got what he wanted. He made case law.
Just because you can do something doesn't mean you should.
Right.
Right.
So that's a photography aspect of First Amendment. Now we're seeing all these cases about harassment aspects of First Amendment. We've been seeing the First Amendment expanded again and again and again over the last really 100 years. And now it's finally time for them to start shaving some corners off and putting, there are some necessary restrictions.
Right. Oh, thanks, thanks, Chris. We actually covered that. So there you go.
Fifth grade, Josh grade, bunch of different folks.
There you go.
And I will say it again.
You have been corrected by an expert. So
we
will apologize again for being wrong. I was confused on the difference between Joshua Gray and Jeffrey.
I know. It happens to me
hold
too.
him down and tickle him later. Do we want to try to power through this?
Yes.
There are some funny, what I consider funny things in there.
And Judy, I'll defer to you if the other one is worth reading at all or not.
And by the way, Chris, nice to have you here. Anyway, good.
Mr. Myers maintains a YouTube channel, Lane Myers Channel for Nonviolent Social Change. He also has a registered company, Freedom Productions LLC. He's a business owner and is an investigative journalist. Although Mr. Myers' methods may be unorthodox,
maybe.
He has a growing list of subscribers, now totaling more than 15,000.
Yep.
Originally on June 4, 2024, Mr. Myers was arrested for booing at a Tucson City Council meeting and prosecuted in Tucson City Court.
Pause. Thanks, Dave, for the $5 super chat. Do others think that fans did just read the phone book and make it interesting? Yeah, that voice.
Oh, Dave.
Yes.
You make me feel all goopy.
All tingly inside.
Originally,
ding 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 at 100.
What?
Ding,
no,
ding,
we're not.
ding.
No, we're not.
Ding 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 at 100.
At 100. What are you talking about?
We're
100 days.
We are at 100 days because we were at 95.
No.
And then Dave.
No.
Dave gave $5, which makes 1 day.
$5 1 day.
Oh.
Yeah.
$5.
100 total.
No, because we were at 90.
No. We were at 95. Dave gave 5, so that makes 1 day. So that makes 96 days.
Oh.
We are not good at this.
Yeah, but we have fun at it.
This is true. The assigned prosecutor was Matthew Walker. Mr. Myers broadcasted his court proceedings on his YouTube channel. He also made videos discussing the case and his interactions with Matthew Walker. Oh, now I can't scroll again. What did the cat just walk? There we go. Okay. Shannon Walker is a public employee who works at the University of Arizona. She was the director of special projects and the right hand of the dean and later the director of alumni and development, none of which has anything to do with her name, work phone number, and work email address are all publicly available online.
Information, yes.
Yeah, it can't be a government website, can't be a
public information.
2024, Mr. Myers left a polite voice message on Miss Walker's work phone number inquiring into his prosecution by Matthew Walker, which again, she has nothing to do. There we go, touche. You've taken care of it. $20. Thank you very much.
Damn it, I was just getting ready to do that.
Your
Oops,
turn.
now 100.
Your turn will come. Mistaken or not, Mr. Myers believed there was a connection and wanted to investigate. See, that's actually, his lawyer's really trying here. You got to hand it to him.
Right.
Miss Walker obtained a civil injunction against her husband and Mr. Myers pursuant to ARS 12-1809, which was served on Mr. Myers on October 17th and upheld on November 14th. Mr. Myers is now in the process of appealing. And how's that going for you there, sir?
We're actually up to 110. 104 days, yeah.
Yeah, but she is in that other time zone, so it won't count until tomorrow. While in the process,
isn't it 105?
Yeah, 100 and wait, 20.
No, 104. $5 a day.
$5 per day.
I majored in mathematics.
Yeah, you don't seem like it.
25 years ago.
Listen.
So
it's
that's
2 a.m.
It's 104 days.
$5 a day. Anyway, while in the process of contesting the injunction, Mr. Myers posted YouTube videos, just innocent little YouTube videos, explaining his defense and interpretation of the law. All very highbrow. Although Shannon Walker was mentioned, maybe once, maybe, because she was a party to the case, no private information was ever revealed by Mr. Myers.
I'd buy that for $1.
Yeah, she was a party to a harassment case. That's different than just being a case that you're involved in. She specifically wants you to... Oh, good God. Mr. Myers never sent the videos to Miss Walker. Mr. Myers only explained the process of obtaining public information and how anyone could contact Miss Walker in her capacity as an employee for the University of Arizona. Although Mr. Myers never contacted Miss Walker and has never encouraged any sort of violence or threats, sadly, a few awful people who should be prosecuted to the full extent of the law wrote disturbing emails and left voicemails to Miss Walker. Mr. Myers believes his competitors and those who want to harm Mr. Myers may be responsible for these messages.
His competitors.
Wait a minute. I have to ask this question. Is his lawyer actually accusing the cop watching and auditing communities of conspiring against Lane Myers?
Yes, he is.
So all those people helping his ass out need to read this.
The state indicted Mr. Myers on charges of aggravated harassment, among others, and Mr. Myers was arraigned on March 14. Mr. Myers has adamantly denied any wrongdoing and claims he is exercising his First Amendment right of free speech. Mr. Myers maintains he had a legitimate purpose under the law. Mr. Myers believes his conduct is protected and legal under the law. For this reason, he has not stopped his alleged course of conduct. After the hearing, but before the minute entry finalized the terms on March 17th, Mr. Myers posted a video explaining his defense. Mr. Myers explained the injunction and why he believes it to be unlawful. No private or confidential information was revealed, except, again, the name of the victim and where she works.
And how to contact her. Yeah.
And he was publicly made. Additionally, Mr. Myers posted a video showing public information.
It's not private information.
Labeled, "Is this a felony?" Yes, Mr. Myers. Yes, it is. The video showed, well, okay, it might be. We're soon to find out. The video showed the public employment information of various employees at the University of Arizona, including Shannon Walker. On March 28, Mr. Myers was indicted with 2 counts of aggravated harassment under ARS 132901.01. Although Mr. Myers is not an attorney, he makes every attempt to educate himself on the law as it relates to his YouTube and journalism activities. Mr. Myers reviews statutes and case law on a daily basis, which he can't do, by the way, because he has no access to a law library. Yep. He educates others on the law through his YouTube channel. Mr. Myers is
press X to doubt. Sorry. Educates others on the law. He educates others on the law. Press X to doubt.
through his YouTube University. Mr. Myers has inspired his viewers to stand up for and educate themselves on their legal rights.
Again, like they all stood up in the courtroom? Oh, wait, that didn't happen.
Details,
I'm
trifling
so
details.
sorry.
Some have even applied to law school. See, the very future of our hallowed profession rests on
sure they did.
Mr.
I mean, if they did, fabulous, then they can figure out how to do it the right way. I mean, that makes me happy.
You know, law schools do need a rejection rate. So just because you applied doesn't mean you got in.
A GED will get you in. Yep.
I don't think we've featured any of his videos on our channel here, have we?
No.
Because if we had, this part would make you confused, because this says Mr. Myers has a history of walking a fine line. And the last time I watched a video, he was a raving lunatic.
Yeah, it's not a fine line. He is way, 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 way over the line.
A fine line in his efforts to exercise his First Amendment rights and promote social justice?
Press X to doubt.
Mr. Myers.
Now this is the same guy who, because DirectD had pointed out a few things where he was wrong, decided to go nuclear and post pictures of DirectD's wife and children and how to get a hold of them.
You know, like you do under the First Amendment.
Well, and especially if you're promoting nonviolence, right? Like, I just.
Yep.
Okay.
And here's the only interesting part of all of this, in that there might be a legal question. Mr. Myers depends on clear and unambiguous definitions in the statutes, so he knows precisely what he can and cannot do beyond all reasonable doubt. This motion to dismiss now follows.
He was asking in the hearing for the rules.
Yeah.
On everything, on how to law.
And this is why judges and legislatures need to give each other special hugs every now and then, because it doesn't always work out well.
No.
Point A. The legislature's conflicting definitions and defenses to harassment, commingled in the statutes, renders the aggravated harassment statute void for vagueness as related to Mr. Myers. A statute is void for vagueness if it is not defined in ordinary terms that people of average average intelligence can understand.
Got a frog in your throat there, Pams? Sorry.
He's average intelligence.
See, Elaine has this problem where he thinks that because he disagrees with it, that means it's not understandable.
Not understandable.
It's understandable. You just don't agree with it.
Although, we'll see. We'll see. No one should be required, at the risk of his liberty, to speculate on the meaning of a penal statute. Now, that's a beautiful sentence.
It is.
And I agree with it.
I bet you we can thank Mr. Parvin for it.
Exactly. When men of common intelligence must guess as to the meaning of the statute and differ as to its application, due process is violated.
Yes.
A court must give effect to every provision in the statute. It must be interpreted so that no provision is rendered meaningless, insignificant, or void. And a statute is unconstitutionally vague if it allows for arbitrary enforcement. Aggravated harassment under Section 13, 292101, requires a valid injunction under 12-1809 and a conviction for harassment under 13-2921. The statute defines harassment as a series of acts over any period of time that is directed at a specific person and that would cause a reasonable person to be seriously alarmed, annoyed, or harassed. And the conduct, in fact, seriously annoys or harasses the person and serves no legitimate purpose. The voicemails left, albeit at by people besides Lane Myers, but his followers left voicemails, including death threats. That fits.
Well, let's not also forget, superimposing your face on the bodies of her husband, her kids, kind of counts.
Okay.
Counts threatening, harassing.
And again, the wife has nothing to do with what his beef is. Right? His beef is with her husband.
Uh-huh. And
where's the beef?
Right?
Yeah.
So
the minor children living at home, going about their lives,
which has nothing to do with the husband. So the fact that he has chosen to go, and take this to someone who doesn't have anything to do with what is going on, except in Lane's mind, he just
and so how a court parses that, and I mean, there is a right and a wrong here, and that's interesting to me. So I'm anxious to see justice be done, and I hope that a badly written statute doesn't wind up.
I don't think it is badly written. I think that what Lane always leaves out is the annoyed part.
Mm-hmm.
Right? A reasonable person can be annoyed by all the things he's doing.
Yeah.
He tends to gloss that over. It's
baldly malicious. It's not. I mean, she's not.
Correct. I don't think he was going to be donating any money to the law school. I could be wrong on that one.
And yes, he didn't contact her.
Role.
Right, he didn't contact her. He also has the mistaken belief that because the law school gets tax money, that makes her a public employee.
State actor.
Right. So again, right, he is the living example of Dunning-Kruger. He's convinced he's right, and all evidence to the contrary, be damned. I'm not wrong. I'm telling you this is the law. And this is a statement of, I'm telling you what the law is. I can't understand it, but here's how I didn't violate it.
Harassment under the statute is defined as a knowing and willful course of conduct that is directed at a specific person that a reasonable person would consider as seriously alarming, seriously disruptive, seriously tormenting, or seriously terrorizing the person, and that serves no legitimate purpose. It does not apply to constitutionally protected speech or activity, or to any other activity authorized by law. Okay. The related crime of stalking under Section 132923 provides a defense to causing communication if there is a legitimate purpose. It does not apply to constitutionally protected activity or other activity authorized by law. Harassment under 132921E is defined as conduct that is directed at a specific person and would cause a reasonable person to be seriously alarmed, annoyed, or humiliated, or mentally distressed, and the conduct, in fact, seriously alarms, annoys, humiliates, or mentally distresses the person. The phrase causes a communication is not defined. There is no defense for having a legitimate purpose. There is no defense for all constitutionally protected activities. Isn't that, I mean, that's what the Constitution's for, but maybe that's just me.
He's also making the logical leap that all of his activities have been constitutionally protected.
Well, correct. Of course they are, because he said them, and you have free speech.
Well, yes. There you go.
Correct.
The only exceptions are a lawful demonstration, assembly, or picketing. Social media is not protected. Online activities are not protected. Every other type of speech, except for the three specific activities listed above, can be prosecuted as harassment in violation of the First Amendment. That's a reach. That's a reach. No intent to harass the individual is required to be found guilty. Mr. Myers depends on well-written, clear. He depends on, does it? Well-written, clearly defined statutes in his quest for social justice and to ensure everyone's First Amendment rights are protected. Some may not agree with Mr. Myers' methods, but nonetheless, Mr. Myers depends on these statutes. Mr. Myers is now being prosecuted for felonies due to vagueness. As the videos submitted to the bond hearing showed, Mr. Myers was just explaining his defense on appeal for the injunction against harassment under 12-1809. He was explaining his defense to charges and why he is innocent. Mr. Myers asserts he had the legitimate purposes of criticizing the work of Shannon Walker as a public employee and identifying alleged government corruption. Mr. Myers made it known it was not his intent to harass.
Oh, well then.
Uh-huh.
I mean, just listen. He was being Doge before there was Doge.
Exactly.
Yes.
Identifying alleged government. We should thank him.
Didn't
Thank
he
you,
just
Lane.
point out that you don't need to, you don't need the intent to harass to be charged with it?
Yeah.
Mr. Myers posted a video
It's
about
irrelevant.
how to find publicly available phone numbers and emails online. Of course, he specifically showed how to publicly find one person's phone number and email, the person who had an injunction against him and a judge's order for him not to divulge that, but never mind.
Correct.
That was such a coincidence, Pants. Pants, it was just such a coincidence.
So that wouldn't be causing a course of conduct or anything like that,
Couldn't
possibly be it.
You can ignore judges' orders when they're blatantly unconstitutional because you say so.
Well, and you have the right to appeal those judges' orders, and so clearly they don't take effect until. Oh wait, they do. Oh, the videos were made to educate his viewers. Mr. Meyer often showed the civil and electronic definitions of harassment. They require there to be no legitimate purpose and that the conduct does not include constitutionally protected activity. This is starting to sound repetitive.
It is.
A little bit.
He explained why he believed his current conduct is not harassment under the law using these definitions. These videos show Mr. Myers intended to conform his conduct to the law rather than harass. Oh, yes.
Wink, wink, nudge,
his
nudge.
videos absolutely show he's just working real hard to conform his conduct.
Wink, wink, nudge, nudge.
Mr. Myers welcomes the opportunity to tell his story to the jury.
Oh my gosh, can you imagine? Can you imagine?
I would love it. I would love it. I'm waiting for the show. I'm getting my popcorn ready. I am waiting for the show.
Would be at risk of gnawing off limbs and trying to escape through the windows.
Can you sit in the jury box and laugh your ass off?
But remember, at the last hearing, he said he was going to plead.
Yeah.
So which Mr. Myers are we meeting today in the motion?
No. He's
Dr.
going
Jekyll or Mr. Myers?
No. He's going to plead because he gave them three options.
Yes.
That was his plea.
He's going to plea on his terms.
Yes.
Yeah.
The problem is he could be found guilty as charged under this unconstitutionally vague statute. The statute does not allow Mr. Myers to assert he had legitimate purpose. It does not allow him to assert that he was criticizing Ms. Walker in her capacity as a public employee, despite the constitutionality of such criticism. He was not picketing, creating a demonstration, or assembly. Mr. Myers was using social media. Social media is protected under the... I'm pressing X so hard here.
Yeah.
Social media is protected under definitions of harassment, but not under 1329-21. Mr. Myers is not permitted to explain he had no intent to harass Ms. Walker. Intent is not required under the current statute. Didn't he just say this? The current legislature is aware of this problem. It realizes it made a mistake and created an unconstitutional statute. It is in the process of fixing this mistake. by passing HB 23. Until then, this court must rule the statute vague. Person of ordinary intelligence.
Must.
What?
It must. It must.
Well, it's because it uses a reasonable person test. It doesn't matter what he intended. If a reasonable person would believe that that's what he intended, then as far as the law is concerned, that's what he intended.
That's a possible argument. A person of ordinary intelligence would not understand what is and is not protected activity under the current version of the statute. He's so confused. Poor Lane Myers. What is he to do? I mean, he could choose not to serially harass somebody in video after video after video, but he'd be confused as to whether or not that's his right to do. With such vague terms, the state can arbitrarily decide whom to prosecute because the intent of the individual has no bearing on the case. Anytime a public employee is annoyed or gets their feelings hurt over criticism, they could claim harassment and demand prosecution. This is an unacceptable application of the harassment law. This court must render it vague. The legislature's removal of the requirement of intent rendered the statute impermissibly vague as applied to Mr. Myers. I'm thinking we can skip the rest of this because it's the same argument again.
But again, they're going to have the same problem that they've had with a lot of their other appeals and motions. They've cited no statutory authority to do what they're asking to do. They cited no law. I would be very surprised if this law has not been challenged before and upheld. So, these are great conclusionary statements
about any of these arguments if it had been Mr. Walker getting harassed, because he was actually working in his state capacity as a prosecutor of Lane Myers.
Correct.
He went after the wife. The wife is
and the children.
So not only is it vague, now they're saying it's overbroad. The statute's overbroad and a violation of the First Amendment if it's designed to punish activities that are not constitutionally protected, but includes within its scope activities which are protected. But even protected, like, if you go to a protest and you shoot people, that's not, I mean... Distributing public information to third parties is constitutionally protected. Under circumstances, sure. The distributor of such information may not be held liable. So that makes me want to look up that case and see if a 1939 case. Do you think that applies in today's social media landscape?
Absolutely.
Absolutely. Social media is protected under the First Amendment. Again, that's... Well, okay.
What social media did they have in 1939?
Yeah. So now
it wasn't that. It's okay. So they're trying to bolster their argument by coming up with analogous arguments. But again, I'd be interested to know if this law has already been challenged and if it has been upheld. Because if it's been challenged and upheld, all of the things they're saying are moot.
Yep.
Anybody have a LexisNexis subscription?
I don't.
No. I drive an Audi.
The claim that expressions are intended to cause a course... Wait, is this sentence broken or is it just me?
Nope.
There's a missing word here. Intended to. The claim that expressions are intended to cause a coercive impact on respondents does not remove them from the reach of the First Amendment. Oh, that's one of those sentences that's working harder than it should.
Yeah.
The court previously ruled regulated conduct and not speech because it required the specific intent to harass and was based on the underlying purpose of communication. As discussed above, this is no longer the case ever since the legislature removed the requirement of intent. Now, anyone can be prosecuted for giving a bad review online. So that's an interesting question. If you leave a 1-star review of a restaurant and some idiot goes and shoots up the place, I think you could argue that just having left that review, you know, there
Right.
isn't a causal link there. That's not this case.
Right.
That's not this case.
Correct.
He said over and over and over again in his videos, she needs to be held accountable. You need to redress her grievances with her.
Right. You need to be upset. You need to be upset over what I think happened to me, and you need to voice that grievance.
Yeah. At the wife of the guy who did it to me.
Yeah. Yeah. Well, his claim is, and this is why he's going after this woman, right? Is his wife used to work for the University of Arizona.
Right. This separate issue.
Right. And she was fired, and he thinks this woman had something to do with her being fired, even though the timeline in no way works out.
Or her job description, or
anything else, right? The lady he's going after has nothing to do with disciplinary action that his wife may have received. She would have no way to influence that, and she would have no way of influencing the timing, right? So his nexus to all of this is she's married to the guy who's prosecuting him, and therefore it's this giant conspiracy that guy wanted to get back at him by having his wife fired.
Phil, are you saying that Lane Myers can obsess about things that have no basis in reality?
In reality, yes.
Shocked,
Yes,
I tell you, shocked.
Yes, I am saying. So, again, this is a personal beef, right?
Yeah.
That he's taken to the internet and he's trying to claim as a First Amendment issue.
But Phil, don't you see how this is exactly like criticizing a politician online?
Yes. Yes.
The state can just selectively choose which public figures they want to protect with selective and arbitrary prosecution just because some people leave some death threats on a voicemail? Come on now.
Well, or actually are in Congress and under the debate and
Have we not seen massive protests across the nation? Are we getting rounded up?
No,
I didn't realize.
The feds can investigate a representative for being critical of the president while in the function of their congressional functions, even though the Constitution guarantees them the right to be able to say those things without prosecution. But yeah, Lane Myers as a First Amendment advocate. Okay. Read the room, Lane. Read the room.
The reason Mr. Myers is being prosecuted is because third parties are contacting Ms. Walker on her publicly available work email and phone number. There's no question that some of the things these third parties are saying are despicable and not protected speech. The harassment statute very clearly was meant to prohibit this conduct. The fact that without Mr. Myers, the conduct wouldn't have happened seems lost on this particular lawyer, though. Mr. Myers is being prosecuted due to the success and reach of his YouTube channel. The state is prosecuting Mr. Myers' exercise of the First Amendment to criticize public employees and post public information. The state is taking advantage of the current statute's overbreadth, which does not require intent. You've said that before, and again and again. Yeah.
Okay, what Lane and his lawyer are also failing to take into account is that yes, you have a right to criticize public officials, right? The definition, though, generally speaking, of public officials has to do with who's elected and who can exercise government power. So a person in a call center while they may work for the state, doesn't have the power of the state. They can't effectuate anything. They have no
Yep.
power over you.
But your
So,
taxpayers go to her salary, Phil. She works for
right,
you.
right, and this is the flaw in their logic, is that is not what those things are talking about, right? I have a right to criticize my government. That's true. It's the government of the people, by the people, elected by the people. So elected officials.
So this is the very crux of their argument. The state's theory is that Mr. Myers caused a communication simply because he talked about the injunction and posted how easy it is to access government employees' publicly available work information.
Which is what they're wrong on, because he's actually gone after her himself. So they're going to use his own words against him.
Yeah, and that argument works exactly once, and that's before the injunction was filed against him.
Correct.
Once the injunction was filed against him, now he's on notice. He must not mention her, and he did anyway.
Right. And the judge specifically told him, you can't do that, right?
His lawyer argues, never mind that Mr. Myers did not directly or even indirectly contact Ms. Walker in the videos. So the state's theory shows that the harassment law is unconstitutionally overbroad. It's understandable. Oh, this is the compassionate part here. It's understandable that Ms. Walker has been harmed. Those responsible for harmful and illegal messages should be prosecuted on full extent of the law. However, the state's wrongfully using Mr. Myers as a scapegoat, a righteous scapegoat.
Scapegoat, I tell you, scapegoat.
Impermissibly overbroad and violates the First Amendment. This court must dismiss. If the glove does not fit,
you must acquit.
Wherefore, blah, 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 First Amendment respectfully submitted. Oy. I'm looking forward to what's her name's reply to this.
Yes. The
prosecutor. Yeah.
Yeah. Because what she's written thus far has been on point and succinct and just beautiful. And I would love to see these arguments just taken apart.
Yes.
And the other motion is just about him saying that he has a right to a rebond hearing, which I think he does. So that's boring.
And everything should be moot because he's being persecuted instead of prosecuted. So there you go.
Well,
moot. It's moot, I tell you, moot.
The problem he's going to have with this bond hearing is the same thing that comes up. He's already on felony bond, right? He committed another felony. So under Arizona law, you're held without bond.
That was actually...
Well, and I would feel different. See, if we've seen these two versions of Lane, the hopped up on drugs crazy pants Lane, and then this new Lane who was like actually being respectful and everything. If the respectful Lane had been at that first hearing, even though the statute says, if you pick up another charge, you must be held without bond, I'd feel differently about it because it's a major inconvenience for him and it's harming his defense, et cetera, et cetera. But a little too little too late. I mean, he was acting like a madman, and the judge said, all right, well, to protect people, we're keeping you in jail.
The sort of devil's advocate I will take with you on that is it's harming his defense. It's harming the defense he's chosen, right? He could do differently. He has the ability to have court-appointed lawyer. He's choosing to not take it.
Yes, this is true. Although, I mean, there is a very real argument that anytime a defendant is incarcerated, it to some extent hinders their ability to aid in their own defense.
Yes, but
as
But
a rule, we want
again,
courts to give people the opportunity to, for instance, be on home confinement or something like that.
yes, we do. But again, he's on felony bond release. Stop committing crimes, asshole.
Yeah, that's
You did it to yourself.
That ship sailed so firmly that yeah, it'll be
And it's
interesting to
hard
see
for
what.
a ship to sail in Arizona. Let me tell you, it is hard. We have scuba shops around, and I look at them going, where do you practice? What?
Wait, how long of a drive is it up to Lake Mead from there?
Lake Mead's quite a while. Lake Havasu's probably quicker, but it's still a couple hours.
Yeah.
I mean, I know people that will like go scuba diving down in Mexico because it's closer.
I mean, depending who's with me, I'd go scuba diving in my bathtub.
Well, there you go. To each his own. But yeah, I mean, like the first time I saw Marina in Tucson, I was like, really? Oh, okay.
If you stare at the desert sand with the sun beating down on it, the mirage shimmers. And behold.
Yeah, the boat's still not going anywhere though. The boat's still going to be staying put.
Yeah, well, there's that.
Okay, I have a quick thing we can watch that will give an example of what's probably going to happen to Lane when he's in court.
Dave's suggestion is good. He says, watch the movie called Liar, Liar.
Yeah.
That's the Jim Carrey movie. That is very funny.
District Court of Greenwood County, Kansas.
I never got why he didn't
This
just
matter
remain
comes
silent.
on for review in 2024 TR 617, State of Kansas versus
old
Abel
Squishy Gardner.
Estrada Jr. Paul E. Dean appearing for the state. Mr. Abel Estrada Jr. appearing in person and pro se via Zoom. Now, Mr. Estrada, you were convicted of displaying an illegal license plate. You apparently had a legal plate in your car, but you chose to put on your car one that
doesn't it sound like Lane? Doesn't it sound like Lane?
Ordered, specially made from a company, and I can't remember at this point what it said. You didn't like the decision, and
this, Your Honor, this is an exhibit.
There it is. Thank you.
Oh, and handicapped even. Nice.
So, and that was manufactured at your request by a private vendor, and you were found guilty, and you said you were going to appeal. I don't believe you have paid. I don't believe you've posted your appeal bond. And then you filed some motions for today, but the main concern is you need to either pay or appeal, perfect the appeal. And if you don't, I'm going to have to direct the clerk to send in the notice to the state to suspend your license for non-payment. So let's take a look at the file. Okay, I do see something dated 2/19/2025. Appeal, notice of appeal to appellate court, and you filed that. Notice of appeal, so you started the appeal process. But typically they don't accept those until
all of this over
$185
license plate ticket.
You did not pay that cash
for a
bond,
fake
did
plate.
you?
No, I didn't. I actually did the proper, and I got a letter from the appellate.
He's trying to say in form of pauperis.
I sent it in, but it needed to be signed, so I submitted. As soon as I got it, I submitted it to your office, and then they told me at your office that you wanted to see me today here about that letter. All I need is to get a signature. I perfected all the paperwork. For some reason it didn't go, but if I get the signature, then I'm continuing. I'm doing everything is supposed to.
Well, I see you filed, one page, it says motion to proceed in form of papyrus. I, Abel Estrada Jr., is disabled and am requesting for a waiver of court fees for the appellate court. Sincerely, Abel Estrada Jr., and it's signed and dated 2/28/25. Well,
Okay, hold on. Disabled and poor are two very different things.
Yes.
Apparently, Mr.
I did look up his
up to the
court
district
cases.
court to make that determination on an appeal.
He
I would have
and
thought
his
the appellate
wife
court
are
would
the
have made.
subject of multiple debt collection lawsuits in Kansas.
And can't, yeah.
So I
So
believe the
he-
poor part.
Okay, that just one does not equate the other, but okay.
That would be my understanding as well. I don't know what letter Mr. Estrada's speaking of. We don't have anything. I don't have anything that shows. I've got the notice of appeal. Mr. Estrada has not been sending copies as would be required to opposing counsel of his filings with the Court of Appeals. We've received nothing. Mr. Estrada, in criminal cases, civil cases, whatever kind of case you're involved in, when you have another side to the case, which is always the case, if you file something, you're supposed to be providing copies to the other side so we know what you're doing. Just as we file a notice or something of that nature, we have to send you a copy. If we file a motion or something else, or they did the initial complaint, you get a copy of it. Etc. So I don't know what he's speaking about. I just know that we've had judgment for some time on this case.
As angry as this guy gets.
And let me see.
But I like him because he shows more emotion than Regier.
Well, I showed a journal
That's a low bar, but true.
Trying to see if it was filed February 21st, and that shows that he was found guilty of displaying unlawful tag.
I think he's still within his 60-day docketing time period, so.
I think so too. So, Mr. Estrada, what is it you want to say?
Here's the letter that the appellate court sent me saying that I just needed the, sorry, this one. I just needed the signature on the papyrus, form of papyrus. I don't know if you can see it.
No, we can't. Why don't you read it to us, Mr. Estrada?
Trying to trick the judge to sign a paper.
If you want to skip ahead, the letter doesn't say that.
Mr. Estrada, the office received on April 2, 25, your certified envelope postmark.
Ma'am, hold on a second. Sorry, could you come more in front of the screen because we're getting a really I'm at least getting a muffled sound. I can't really.
I can't track it. If you get in front of the camera and tell us your name.
Ladies and gentlemen, Mrs. Estrada.
Anna Estrada.
Annie Estrada.
Annie, A-N-N-I-E.
Yes.
Anna Estrada, and you're the wife of Mr. Abel Estrada Jr.?
Yes.
And you have a document in front of you with the Court of Appeals? Okay. If you'll slowly and loudly articulate that, because it is very muffled for some reason.
Did you want me to read the whole document?
Well, just the
pertinent part.
Okay.
Body of the letter.
Okay.
Where it says, I'm assuming dear Mr. Abel, and then whatever's below that, or dear Mr. Estrada, excuse me.
Yes, the office received, Mr. Estrada, the office received on April 2, 2025, your certified envelope postmarked March 31st, 2025. You enclose the documents which we have reviewed. At this time, you're unable to docket an appeal based upon the following issue. First, we need either the docketing fee of $155 or a file stamp copy of the signed order of indigence by the district court judge. You have enclosed a motion to proceed in form of papyrus, but no order by the court has been provided. Next, we need either a file stamp copy request for transcript document filed with the district court with service on both the court reporters and opposing counsel, or a statement that no transcripts will be requested with service on the opposing counsel. A request for transcripts must note that it is being made for purposes of an appeal and must comply with rules 2.04 and 3.03. Finally, please be advised that docketing must occur within 60 calendar days of the filing of the notice of appeal with the district court. If this does not happen, then it will also be necessary for you to submit a motion to docket appeal out of time to this office, along with the items noted above. This motion must also be served by you opposing counsel.
Yes.
It appears your deadline for timely docketing would be April 21, 2025. As a result, a motion to docket out of time is not currently required, and we cannot hold the motion you have submitted as it does not serve your opposing party. Only the appellate courts of Kansas. The remaining documents you have
So
submitted
you don't have what you
will
said
by
you
your
had.
office on your behalf for a period of 6 months pending receipt of the items noted above. This office is unable to provide legal advice or assistance.
All right, so you have not perfected your appeal. You've merely filed a notice of intent to appeal. Sounds like that's the only thing you have, and that the Court of Appeals is not officially recognized.
Your Honor, it also sounds like the Court of Appeals gave him a checklist of things he needs to accomplish that we're not authorized to advise him how to complete.
Right.
Thank you, Sue Bear.
Clearly you have.
For the 3 gifted memberships, can somebody
No,
see those?
member for 3 months.
Oh, member for 3 months, sorry. Oh, congratulations, Sue Bear.
Docketing sounds so made up. Listen, we don't kink
Sir,
shame here.
because the Court of Appeals just told you the list of things they need you to do, including sending a copy and certifying that you provided me a copy of things that you file with the Court of Appeals. They specifically
Don't interrupt me. Let him finish.
They specifically advised you that you had not. And I have not received anything from you except for this motion to dismiss liability, which, Your Honor, I don't know that I have anything to argue on that other than it's nonsense, and I'd ask you to deny it.
If you'd like to see that,
I mean, I don't even know what he's attempting to do, whether he's asking the court to reconsider the judgment. Doesn't state that, whether he's asking the court to make an indigency finding. He has presented, other than naked statements that he claims he is, has provided
Naked
nothing to the court to make that consideration. Or whether he's asking the court to waive.
I don't think we can show that on
say
here.
that either, but those are the 3 logical conclusions I could come to that he's trying to request. But I don't believe anything's been presented that would give him relief.
Note time
change their
stamp.
opinion about the guy.
Note timestamp, Jim. They said naked.
Least, and that's all I have to say on the topic.
On your motion to dismiss liability, let's take that up. It says, I reserved my right not to be compelled to perform and under any contract or commercial agreement that I did not enter knowingly nor voluntarily or intentionally. Furthermore, I do not accept any liability of a compelled benefit of any unrevealed contract of a commercial agreement. And then it's signed Abel Estrada Jr., living man, authorized representative for Abel Estrada, straw man.
Of course it is.
Now, I'm going to deny that because I share the state's comment or belief that it makes no sense. It doesn't have any legal argument in it.
Though. It's got a
so motion to dismiss liability, whatever in the world that's intended to be, is hereby denied. And let's see, journal entry of
thank you, Sue Bear.
Did you file that?
One more
Maybe
day.
journal entry of continuance, Your Honor, maybe the last one where we were reviewing the status of the appeal and or the payment of costs and fines.
That's what that was. Okay.
Yeah, the payment of the appeal bond. So I believe that was a late April date on the perfecting or
I agree. I suddenly want salad.
So I would ask the court to set this over to someday in early May. But it hasn't been properly completed at that point in time. The state would be moving to dismiss the appeal.
If I may, I did submit copies of everything that they asked me to your office. And by the way, the actual April letter that I sent certified, that was the second letter that I sent. I sent it because when we went to court the last time, it didn't seem like you guys got anything, so I resent all the paperwork again for the second time. But all they're asking right now is the papyrus indigents, which you already have, and then the request for the records. I already sent it in, and I sent the COA. So I did the paperwork. It's been sent, and you guys, everybody got a copy of it, or at least at the court of record. That's what they told me. They said, do I need to send one directly myself, or do you get a copy? And I told him, Mr. Dean, the judge and Mr. Dean gets a copy, and they say, no, don't worry, they get a copy. So I submitted that to you guys already.
Okay, when you say I submitted to you guys, who do you mean?
I'm sorry?
Who do you mean when you say I submitted it to you guys?
To the court of record.
Who is the court of record? Is that the district court? Is that the court of appeals? Did you send it to the clerk? You sent it to the judge?
I sent it to you directly, magistrate, and I sent it. I put it on the court of record. So they told me there at the court of record that you're gonna get a copy also.
That's next.
That's why I submitted this already.
Okay, order to remove the documents should not be filed. I see where I signed off on an order to remove a document from the record that you had apparently misfiled, a motion to docket appeal out of time, and it was premature. You shouldn't have filed that, so that was removed. Missy, didn't you?
Yes, I'm here, Judge.
Missy, can you help straighten this out?
There was a paper. Let me see. Let me go see what it was.
See if it's at the clerk's office. But as far as the informa pauperis, I have not made that determination. I did appoint you, perhaps I shouldn't have an attorney since this isn't or wasn't the level of a jail sentence that would have entitled you to the right of an attorney, and you fired that attorney, and then
I apparently rage quit.
Another one, and you didn't want to use him. But as I recall, you do have a monthly income. And remind me, does your wife work?
No.
Okay, well, I have never seen, I've never made that determination.
Trust me, bro. Trust me, bro.
And I'm not inclined to make it at this time. You do get some income, as I recall. And if you can afford the transcript to be made in this case, I don't know why you couldn't afford to pay the filing fee.
He just doesn't want to.
I'm requesting the papyrus because it'll cover it, and then they told me at the court this morning that when I do the request, that it's not gonna be charged to me. I don't have to pay for the request, and all I need is the letter that I submitted, which is for some reason they're asking for you to sign, so I submitted it to you as soon as I got it.
Your Honor, I would respectfully request the court to the court's denied the motion that was before the court today. Set this matter over to early May. Mr. Estrada wants to argue things, in my opinion, to this court that's claiming conclusory issues that it's been completed, yet the letter that was just read to us specifically contradicted numerous things that he said that he's done and taken care of. I just sent a message to my office to confirm that Dylan, we've received his copy of the of this motion to dismiss liability. I'll give you one piece of advice. When you're filing something, what the court said is you need to send notice to me. You put a certification here at the bottom saying, listing everybody, whether it's Greenwood County Attorney, the District Magistrate Judge Webster, and their addresses, and the date you mailed it. That goes here. That's called a certification that you provided notice to the other side so the other side can properly respond. Nothing. I don't even know that you actually know her address, but in any event. I think Mr. Estrada has a number of issues that he's been specifically told in that letter that needs to be addressed, and he needs to address them in the fashion that he deems appropriate. And we should review it in May.
All right, Missy, what do we have in May? All right, I'm going to continue any remaining matters. Well, I'm going to continue the pay or appear.
Exactly, Dave.
May 11, 9 a.m.
He just doesn't get it.
I get the distinct
You
feeling.
have to have that paid and cover all of those matters.
Yeah.
I get the distinct feeling that a clerk mentioned something about the, not having to pay if you can get the judge to sign this. And that translated to, great, I don't have to pay. I just need to get her signature.
Right. And it basically is going, well, I just don't want to pay it. Right.
And if someone seriously needs help to file a lawsuit, I'm all for it. I don't think he's in that boat. That's just me.
I don't think he is either. I think he is. Again, this has so many parallels to the people we've been talking about today, right?
Yeah.
He has an idea of the way it should work, and that's how it should work. And what do you mean I didn't do it? I think it should go this way.
And you can think that. It doesn't mean it will.
I think you should just know everything that I think.
Right.
And agree with it.
Right. I filed it with the court. I filed it with the court. How do you not know it? What do you mean I have to mail it to you?
Appellate court is listed, including paying that appeal bond, also known as a supersedious bond. That needs to be paid of $158 cash. So,
may I ask a question?
Go ahead.
Yeah, I just need to know if you're going to sign the form of papers letter that I sent you.
No,
I'm not signing that at this time.
That would be holding justice from me.
Well, so you believe. You also believe my decision was holding justice from you. That's my order at this time. I'm not going to sign it, and I'll take your pay or appear up at the date and time given.
Or there's a particular procedure that you need to research on how you go about making that request to the courts. You don't just send a document saying, "Fine, make this finding," without support. That's not the way court works. Your Honor, I'd ask the court to go ahead and approve this journal entry, since these documents will be needed, probably potentially supplemented to an appellate record. Mr. Estrada, if you agree that this is what we did today, then you can say yes, and I'll put an S/ showing that you approved it. If not, Your Honor, if he's objecting, instead of going through the whole lengthy Rule 170, I just ask the court to approve it if it agrees. This is the case caption, case number, the date that we all appeared, that you appeared, or that Judge Webster was hearing this matter, that you, Mr. Estrada, appeared via Zoom, that this case was set over to May 9th at 9 a.m. And it's, set over as a continuance. It's not granted, or time's not charged to any party because this is on appeal, and that it's set over regarding pay or appear and or completion of the docketing. Oops, I need to finish putting on statement. Completion of the docketing statement.
Now,
So
this is
that
what you
box, and
call
there's no need
judicial
for it.
economy. Let's just not bother mailing it to this guy because he's not going
And
to
there's
accept it.
nothing else contained.
I'm sorry.
I guess I should have put that the motion to dismiss liability was denied.
Yeah, but that is denied.
That must have been what I was planning on, and then we got to discussing some other issues.
And you might put in there that the defendant needs to either pay or post his appeal bond and perfect his appeal, something to that effect, by that next court date.
And that was 11 o'clock on 5/9, right?
Yes, I was gonna ask about that.
Oh, I had it. Okay.
Missy said 11.
All right, I'll get that changed to 11.
I wonder, Missy can,
Yes.
no, just leave it there.
All right, if we can do it at 11 if you want.
No, that's fine. Whatever you have.
Missy, thank
So
you.
it's 9 o'clock or 11 o'clock?
Whatever Missy says, that's what we're gonna go with.
I've now changed it to 11. I thought that's what everybody wanted.
Okay.
Okay.
Thank you, Missy.
Change that to 11 a.m. And then Your Honor went ahead and added what we just discussed, that the motion to dismiss liability is denied, and further that he needs to complete the docketing of his appeal. Complete the docketing of his appeal, pay the appeal bond, or pay the case in full by the next court date.
And if anybody wants to take Dave up on
Mr.
his
Estrada,
bet,
do you agree?
there
that
you
that's what the
go.
court just
I
did?
am not. Because
I
he will
hear
get
what
it
you're
all
saying.
wrong.
Your Honor, to ask the court to approve.
Approved. I understand you don't agree with the orders, Mr. Estrada, but they are what I ordered.
Exactly.
And I don't
simply
like
on the defendant's signature line going to mark approved over defendant's non-response to the correctness of the order.
Basically just
All
writing,
right.
suck
I'll
it.
submit that. Is that acceptable to the court, Your Honor?
Is that acceptable?
That is acceptable.
Yep.
There's nothing further. We'll be in recess on this matter, and Mr. Estrada is excused.
Thank you.
Thank you.
But
Show my screen real quick, Phil.
yeah.
This is that motion that the prosecutor is holding up, and this is how he signed it. Abel Estrada Jr., living man, authorized representative for the straw man, for Abel Estra Jr. Oh, missed something. I'll just scroll in.
He can't even spell his own straw man name right.
Straw man. And then I thought this was the court seal, but no. See what it says? A living man in the middle.
Oh, wow. He paid good money for that, didn't he?
Yeah, something I can't tell exactly, but there's
like
Estrada Abel
year.
Jr.
Yeah.
And then without recourse, UCC 1308. So he's being fed this crap by somebody.
Wow.
Yes.
Some guru is a lot wealthier because of them.
Yeah.
But he can't afford the filing.
Yep.
It changes my opinion because now I think of him more as a victim than a, because he was pretty polite,
right,
and very confused, and he feels like he's being wronged because he's been given this terrible advice.
The problem I have, I agree with you in principle, Pants, and I think maybe the first time you're going through the court, I can buy that argument.
Yeah.
But he's now on appeal, being told all of this is crap repeatedly, and yet continuing on, you become a willing participant.
Mm-hmm.
And again, this is all of, he had his own license, an actual license plate from the state of Kansas.
Right.
Right? So he could have cured this by simply putting on the actual license plate he had.
He
but
told
no.
the officer he was mailing it back when pulled over, and
Yes.
then said he only used it when he did Uber Eats.
Yes. Yes. So he knows he needs it, right? He knows
Oh,
he
but it's for
actually needs
commercial
it.
purposes.
Right.
He was only using. Oh man,
Right.
that's just. Oh,
He's such a
Muffin,
sweetheart.
no.
I
Yeah.
saw first case.
Yeah. So yeah.
It kills me. Like I want to know what started these folks down that rabbit hole.
I don't know.
Ignorance,
Mm.
Or
a lack of IQ.
lack of education.
that, and also a chance to, okay, I don't have to pay this money, right? I can use it for other things.
Like an MLM. I buy from somebody
Yeah.
that somebody buys from me.
Yep.
Yeah, it really is. I mean, especially the big gurus that peddle this nonsense really is like an MLM.
Uh-huh.
Oh yeah, especially because they keep getting caught, they keep failing, and yet they continue to peddle this garbage.
Yeah.
Like
Then
it's
you
proven
can
it doesn't
pay
work.
your bill.
Stu Bear brings up a good point too, that if English isn't your primary language, your first language,
That's
then there may be other ways of, the other levels of misunderstanding that me as a, first language for me, that I may not get caught in some of those misunderstandings.
True.
But yeah, I'm afraid a lot of it is just like when he didn't want to pay the filing fee. Is it just a way to get out of having to pay fines or pay a registration or something like that?
I think a lot of it is they think that I can save a whole bunch of money. I don't have to switch to Geico, and I can still save a whole bunch of money. That's just,
Save 15% or more if you're calling.
well, we've been going almost 2 hours, which is very long for us. But
I was going to say, Jim's not around.
It's been an extremely enjoyable show. I appreciate our guests coming, and it is a F.U.M Friday, so it's good that Mark was here.
Yep. 111 days.
We are up to 111 days, so let's keep that going. Any last thoughts as we go around the panel? We'll start with our guests. F.U.M, do you have anything to say?
Boobs.
Judy, can you top that?
Lane Myers on Tuesday.
Speaking of boob. Touche.
I'm Glenn Serio Stalker.
And pants.
But did you intend to do it?
Yes, you did.
I have nothing left to say. I'm at a loss of words.
Thank you for the fine reading. It was you're right. It was much more enjoyable than the AI voice. Good night, everybody. Good night, everybody. Be kind to your waitress. Screw the valet.